Hi, everyone. It's a pleasure to be here. Let me tell you a bit about Unshackled Ventures. We are a pre-seed venture capital firm that invests in immigrant entrepreneurs. We invest at the earliest stage, and we support the entrepreneur through the life cycle of the company. And for immigrant founders, we know that visa and immigration are big issues and areas of concern, and we provide full support for these founders that we bring in our portfolio. So today, I have this excellent panel for us to talk about what are some of the options for immigrant entrepreneurs, what are some of the resources that immigrant entrepreneurs have, and my goal here is that you guys leave this session today with some resources you may be able to utilize on a day-to-day basis. So I will let the panel introduce themselves really quickly. Let's start with Jay. Jay's lead immigration attorney at SAC Attorneys, and I'll let him speak very briefly about his own experience.
Thank you, Lucas. My name is Jay Terkiana. I'm an immigration attorney in San Jose, California. I focus on family, employment, and investment-based immigration. Over the last 10 years, I've handled several complicated and complex cases across the nation. I focus on startups and individuals and basically help the entrepreneurs navigate the immigration options in the United States.
Sheetal is from Adams. She's been doing advisory and public accounting since 1996. I would love to have her speak a bit about her experience to you guys.
Good afternoon, everyone. I'm a tax partner at Adams. We are a tax audit and a consulting firm, and we service 30 industries nationwide, but in the Silicon Valley location, we have a highly specialized team which works with technology clients, life sciences, and our private clients. I personally work in the technology sector, and my clients are startup companies to individuals, and as well as I work with venture funds.
And finally, we have Navneet Chugh, managing partner at Chugh LLP.
Good afternoon, everyone. A great time to be here. We love TiE. The first time I attended a TiE conference in Silicon Valley was 1994, and since then I haven't missed one. It's great what TiE is doing around the world. I don't think TiE publicizes enough of how great TiE is, and we're in 65 chapters around the world. Every big city in the world has a TiE chapter. Thousands of members around the world, and what you don't know and what most people at TiE don't know, that you can connect with these 50,000 people around the world by connecting through the TiE website. There's also charter members in each TiE chapter, and once a year there's about 3,000 charter members throughout the world, and once a year we meet whoever wants to out of these charter member group. And because of the TiE charter member group, we've got an opportunity to roam around the world. These TiE charter member retreats happen somewhere around the world. The first one was in '99, which I had the pleasure of doing. We took a cruise to Mexico. And this year in June, it's in Prague. So there's a lot going on behind TiE. And whatever you need in life, in the business world, an entrepreneur, an executive, money, assistance, senior, gray hair help, all of it you can get through TiE. And you all in the business world, you know that you don't make the sale in the first 4 times. The sale really happens when you hit the customer the 5th through the 10th time. So if you get a no from TiE, keep bugging TiE that I need this and I need that, and don't stop. I had the pleasure of starting a CPA and law firm 32 years ago. We're now in 12 offices, 5 in US and 7 in India. We have 600 employees, 300 lawyers and CPAs, and we do full service legal work and full service accounting tax. We probably do more immigration work in the United States than any other law firm, and we're happy to help all of you. We have a 3-page memo for all of you. I think you can get a copy at the back, and it basically talks about the 7 ways you can get immigration into the United States, an H1 and L1 and O and EB1 and EB5 and EIR. and the easiest of them all is to get married to a US citizen. Thank you.
That's a great segue for first question to Jay and Navneet. Let's talk about some of the options, some of the visa options for immigrant entrepreneurs. Jay, why don't you get us started?
So some of the most common options are H-1B, L-1A, EB-5, E-2 visa, and then there are a few options through self-sponsorship, through O-1 and EB-1A visa. We can go into a little bit more details. So I'll briefly touch on H-1B. So basically the H-1B visa, it requires an employer-employee relationship. So technically the visa is not meant for the entrepreneurs to start up their own companies. However, through the course of these last 10 years, we have figured out a strategy where we can set a startup and set up a board, which basically retains the right to control the employment or fire the employee. So we have been successful in getting the H-1B for startups where the H-1B candidate can have the ownership of the company, but at the same time surrender the right to employment to a board, and it's possible to do your own business on H-1B. And then obviously EB-5 is an investment-based visa where you invest $500,000 or $1 million, and you can get a direct green card. And then there are some other options which are applicable to intercompany transfer. So basically if there is a foreign company who wants to start up a business in the United States, then there are some options available through L-1A visa.
We'll go into a little bit of detail on the most common questions on each one of these visa types. But before we do so, Sheetal, can you talk a little about the tax implications of starting, growing, and perhaps even exiting a business with foreign founders here in the US?
Yes. Just before we do that, I just want to touch a little bit on, just the founders themselves and the visa and what tax implications are there with holding different visa. Really, the way the US taxes foreign nationals is that it's got, what your visa status is not going to have any tax implication on how you're taxed. You're taxed based on your tax residency, and that's a mechanical test versus what visa you're holding. So if you meet that mechanical test of being a tax resident of the US, you are going to get taxed on all your worldwide income from the day you become a US tax resident. So here I do want to point out that people, when the foreign founders, when they are looking to move to the US, irrespective of whatever visa will allow them to come and work in the US, they need to plan ahead. They need to look and see what investments they are holding and what the implications are going to be once they move into the US and become tax residents of the US, because how US is going to tax their ownership in various in investments that they hold overseas is maybe, and in most cases is very different than how they're taxed in their home country. So it's very important. The first year is very critical to get the right kind of help when you move to the US and understand what the tax implications are. That's for the founders themselves. For the businesses, there are various forms of businesses in the US that you can incorporate and start. Some, depending upon your residency status, some structures may not be beneficial for a foreign founder. So you kind of need to be, when you're planning to set up a company in the US, you do need to have these discussions to understand what the ramifications of various type of structures. Like a C corp is probably great, but an LLC structure may not be, depending upon your residency status, may not be something ideal for a foreign founder who's looking to move to the US. So that's as far as setup of the business is concerned. Growth, I would say founders, foreign nationals moving to the US and setting up companies here are very unfamiliar with the laws. So it's very important to know that you're taxed at the federal level. The states have their own. Your corporation is going to get taxed at the federal level. States are going to tax your corporation too. There's payroll taxes, there's sales taxes. So just getting an overall education about the whole US tax system is important. It helps you make a decision where you want to place your employees, where do you want your offices to be located, so that you minimize your compliance exposure with various kinds of state and federal tax authorities. So that's the planning that needs to go in.
So Sheetal, a lot of young people come to us and say, hey, I'm setting up a company, get me a green card, I want to stay in the United States. No, and they do a startup, and then they sell, and they make a lot of money. And then you know what I do? I cut up the green card and send it to the government saying thank you. Isn't it true that if you are rich, and if you're going to be rich, then stay away from the United States as much as possible?
That's true. Because once you become, especially if you have a green card, then you are taxed on worldwide income, irrespective of your residency. These tax residency rules only apply for all other kind of visas. Once you're a green card holder or a US citizen, you may not be living in the country and you may not have lived in the country for years. You're still going to be taxed on your worldwide income. You're considered to be a permanent US tax residence if you're a citizen or a green card holder. So that's...
Once a week, we cut up a green card and send it to the government saying thank you. The problem is that some of you that are going to get very rich, you're not getting good advice from us today, saying do an H1, do an L1, do an O visa, do an EB1, do an EB5, get married to a US citizen. Later on, you're going to regret it. United States is the best country in the planet, but if you're very rich, it's a very bad country.
So I just want to add one thing. So actually, Uncle Sam, it's not going to let you go off that easy. Even if they give you a green card, you're supposed to stay in the United States. You cannot be absent for more than 6 months without surrendering your green card. So basically, after getting the green card, there are some options where you can hang outside for a few years by getting a travel permit or a re-entry permit. But eventually, you would have to be living in the United States, and you have to file US taxes.
So I have a CEO client, he runs a $1 billion company between US and India for the last 12 years on a B1 visa. Rupert Murdoch became a billionaire and did Fox and all of that in the United States, and forever he was on a B1 visa. So let's not get too hung up on H's and L's and O's. If you have a successful business and you're going to be a global startup, then think twice and 3 times before taking up a US residency.
So a lot of the audience here today is composed by entrepreneurs who are at the very beginning of their journeys. And a lot of the questions that I hear on a daily basis have to do with specific types of visa or specific options to stay here in the US. One of the questions that we get a lot at Unshackled is, what's the process for you to sponsor yourself after you create an entity here in the US? Can you do that? And what are some of the visa options that are friendly towards you sponsoring yourself? So Jay, why don't you speak about that a little bit?
Sure. So let me start up with the O1 and the EB1A. So EB1A is the visa where an entrepreneur can self-sponsor themselves. So basically this visa requires entrepreneur to meet a 3-point criteria out of 10 criteria. So basically if they have a lot of experience, they have played a lead role, they have been published, they have published material about them, they have published some scholarly articles. There is a way for them to directly sponsor themselves for the green card, does not require any employment sponsorship. The green card can be filed under the premium processing. The I-140 actually takes only 15 days. So for an experienced entrepreneur, there are ways to get EB1A. 15 days gets you the I-140. If they are in the US, they can file the adjustment of status. After filing the adjustment of status, it takes about 6 months to get a work permit. And then basically after getting the work permit, they can start their own companies and work for it. So that is one easy way, but that is only applicable to the experienced entrepreneurs or extraordinary ability aliens. And then outside of that, there are some options obviously through H1B. However, this would require them to partner with a green card holder or a US citizen who can act as an employer, or they can set up a board of director or a management team which can retain the right to control their employment, which can retain the right to fire them. So basically they can fulfill these ingredients and the requirement of the H1B and qualify themselves as an employee. But one thing to be noted here is that if they want to play the role of entrepreneur, then the H1B has to be filed for a level 4 position, which is basically a high salary. So they cannot go in for a level 1 junior position. So that is one of the common challenges. Obviously the startups, they cannot pay a salary of 150K upwards right from the bat. So there are some of the challenges, but we can definitely help these entrepreneurs navigate those options.
So when you talk about extraordinary ability on visa types like the O1, help us bring that down to a common understanding of who that person is and how does the government measure extraordinary skill. Navneet, do you want to speak a little bit about what's the criteria utilized by the government to define extraordinary skill?
Yes, so US, as you know, is a country of immigrants, and if somebody is of extraordinary ability anywhere in the world, there is a way, and US has structured its immigration process that they will make sure that this person can come to the United States without any trouble. So if you look back at every single Olympics, whoever wins, a non-US person, whoever wins of any other country, a coach, that person can simply send a letter to the United States CIS and say, hey, I'm interested. And the O visa is one of the vehicles the government has created that if you are extraordinary ability, then either you can do an O visa or you can do an EB1, which is a green card. And it's probably the fastest way to get a green card short of getting married to a US citizen. And the EB1, which maybe Jay will talk about later, so let me just talk about O. O is, in our immigration world, we have a joke that an O visa you can do for somebody that you can write a 15-page article or a memo about that person. And this memo basically, so it all boils down to that this person has great achievements and abilities in science and technology and mathematics, in art. One of the earliest uses of the O visa was Nadia Comaneci's coach, the Czech woman in 76 or 80 who won a lot of Olympic medals. So if it's an extraordinary ability you have, you are an extraordinary citizen, and you published papers, you've written magazines, you have a PhD in a particular thesis that could be of importance to United States. And given how the United States economy is the biggest in the world, and we're into everything, every single extraordinary person can come to the United States because US needs that person. So create a life that somebody can write a 15-page article about you and we can get you an O visa.
I think so many people today are asking questions about the current administration and new policies that are coming into play, both on immigration, tax treatment, and the overall state of the economy, and how do these new policies affect immigrant entrepreneurs. So I would love for the whole panel to speak about this a little bit, the perspectives on current policies and how do you see the next 3-4 years panning out. And Sheetal, I would love to start with you.
From a tax standpoint, because like I said, the visa status doesn't really impact how the US taxes you. It just depends upon the tax residency of the person who's moving into the country. So, and I don't see too much changes there. So, probably I think the other panelists will probably be able to give a better input on that.
Sure. So this is a little bit of a speculation, obviously. As immigration lawyers, often we are asked by the clients to take a guess, what's going to happen, how my particular visa or how in general the immigration is going to be impacted. So I'd like to touch base on the few common topics. Firstly, let's talk about the EB1. So one trend that we have noticed is that after filing the EB1, so we file the I-140, that gets approved, and then in the past, once you file the adjustment of status, it was purely administrative. So basically there was no questioning or request for evidence on the 485. What we are noticing is that there is an increasing trend. Immigration, even at the last stage, basically at the 485 stage, they are giving RFEs and they are asking to establish that how a particular alien of extraordinary ability, how that is going to benefit United States. So basically we have this case of a fin swimming champion. She won basically Olympics, and the EB1 was fairly quick and easy. We got the I-140 in like 10 days. But at the I-485 stage, before they gave the green card, they are like, how do you benefit the United States? And there is no fin swimming team in the United States. Basically, the only way we got ahead with that was that we gave argument that this person basically could act as a coach and then sort of set up a new team for the United States, and which will leverage United States to become a participant in the Olympics. So we are, in my opinion, I think they will question all these sorts of visa more heavily, especially in H-1B. They are going after the 7th year extensions. So right now the H-1B is maximum time allowed on H-1B is 6 years. It is possible to extend beyond 6 years, and Trump administration, they have indicated that they may target this rule that especially Indian and Chinese born, they may not be able to extend the H-1B beyond 6 years. Lastly, I also think they will question the AC-21. Basically, AC-21 is a regulation which permits Indian born and Chinese born to change the employment once the green card has been pending till a certain point. So right now the rule is that if you file the adjustment of status, it takes about more than 10 to 15 years for Indian born to get the green card. And then once the 485 is pending for 180 days, which is 6 months, they can change their job, they can move to an employer which offers them same and similar job. So in my opinion, Trump administration, they can target this rule and they can basically question more on the same and similar job. They can also question on the location. So basically right now you can move from New York to California and then still argue that it's the same and similar job. But what I think is they can also bring in more restrictions and they may not allow people to move beyond a certain geographical area. So these are some of the changes which can heavily impact the employment-based immigration process.
So we would love to open for audience questions in this 7.5 minutes we have left. We do have a mic in the middle of the hall, so if you want to make your way there and ask questions to the panelists. I would ask that any questions that you ask today remain on a general level. If you have any questions that pertain to you specifically or a specific case, the panelists will be available after this session.
Hi, one of the things was when you're starting a company and hiring people, you were mentioning how to get around that 150K or high compensation in order to get visas. So if you want to get people from overseas, then with a limited budget, how can startups work with that?
Are you asking that, are we talking about the entrepreneur or an employee engineer?
No, as an entrepreneur, how do you hire people because they need to have a work permit. So there was some recent rule that the salaries need to be at such a level. So do you give them more stock or how do you get them a visa to work?
So right now for the immigration purposes, only the actual salary that you pay is considered a wage. So basically any bonus or anything that is not guaranteed cannot be counted as a compensation. So the stocks cannot be counted. There are some options, obviously, to navigate the immigration landscape. For example, instead of filing a full-time, it's possible to file for a part-time position. Then there are also different titles that are available. For example, let's say if you are sponsoring someone for the position of marketing manager, it's a very high salary, it's about 130K. You can choose to file for a marketing specialist, which is about 60K, so that will cut the wages into half. However, you would have to make the justification that why it's not a managerial position and why it's a junior position. So if it's a managerial or a higher position, obviously you are required to pay the correct wage level, which is a level 4.
So as a software engineer, you can get a visa for a part-time job for people?
Yes.
What visa is that?
H-1B.
Oh, okay.
It doesn't have to be a full-time job. You can get a part-time H-1. Also, in practical terms, what companies are doing is when you're a startup and you need to hire somebody and the wage is 120, 130,000, the wage is half of that in certain zip codes in the United States. So if you're a startup, consider having the headquarters here, but your manpower in some other state. There is a 4x difference in salary between the poorest zip code in the United States and the richest zip code. Practically what companies are doing is they've identified this person in India that you want to do this H1 for, but you have to pay them 140,000 in San Jose to keep them in India and do the work in India till you have some funding and have them travel to United States on a B1 visa for 2-3 months and do knowledge transfer, but they need to go back and you really need to get some funding before you hire them, especially in Silicon Valley.
Thank you.
Thank you.
Hi. So, very knowledgeable session. My question goes to Navneet ji and Sheetal ji. You mentioned about the tax rate, especially in cases where acquisitions or initial, annual tax rate, income tax, and the other taxes is concerned. about the US being disadvantageous jurisdiction if you're earning a lot of money. Does that still hold true in the wake of recent tax reforms that have been enacted in the US? I'm talking of a jurisdiction where I'm coming from, which is about 30% personal tax rate, 35 give or two, and 25% corporate tax rate. So the US is still disadvantageous in as far as those transactions is concerned. That's my question.
So you're talking about at the personal level as well as corporate level?
Yes.
Right?
And the capital gains.
It depends. So it depends upon which country you're comparing yourself to. I mean, some countries obviously have a higher tax rate than the US does. And also depends which state you're living in. I mean, California, the highest tax bracket is 13.3%. So I mean, living in California and comparing it with the rest of the world, I mean, you're definitely disadvantaged. Florida doesn't have an income tax. Texas doesn't either. So it also depends upon, where you fall, like in your wage income. It's just the tax brackets that you fall under. So I think we've gotten more comparable now with the recent law change because the tax brackets have broadened. I mean, obviously we don't see that as much in California, but I think people for living in the rest of the states who didn't have to pay state income taxes or have a lower state income tax rate, I mean, they'd probably see a lot more benefit with the broadening of the tax brackets. In California, I've seen people have pretty much come out to where they were, even with the loss of deductions in 2018, they're approximately at the same spot. But comparing to the rest of the world, I think it just depends where you're comparing yourself to. Europe has got high taxes. Canada has higher taxes too. So and corporate rates have definitely come down. I mean, we're at 21% now, so we definitely have an advantage there now. With most countries, I think, or at least we are comparable now.
Things have gotten bad for rich people, no doubt. The poor and the middle class certainly benefited, and the extra ultra rich in California probably got the worst treatment from the new tax code than anyone else. The rich of California lost the state income tax deduction.
Right.
So we have clients that are paying $1 million in state income tax, and that would save them $400,000 on federal income tax, so that's gone. And the entire tax revision code was done to hurt the blue states. There is no ifs and but about it. The mortgage is capped at $750,000. But I encourage all of you to read an article or two on who pays tax in the United States. It will just shock you of how 82% of the tax is paid by 2% of the country. And under $84,000, there is no income tax. The rich of the country benefit from capital gains income because that's taxed at zero level in 9 states and at half the federal level in the entire country. And I must share with you that I was in Singapore a few days ago and I have a client there. He's a rich guy, and this will shock most of you. He doesn't sleep at night because he does stock market trading in the US and makes a few $1 million a year and has been for the last several years. Singapore does not have a capital gains tax, and so he pays zero tax in Singapore. And United States, and this is the shocking sentence that most of you have probably never heard, if you live outside the United States and you make money in the US stock market, tax is zero. So this client of mine, this multimillionaire, he has never paid a dime in taxes, ever, legally.
And on that happy note, I would love you guys to join me in a round of applause to the panelists. We will be here to answer any questions you may have. Thank you.